We're getting some details now. This is with regards to the cases that are coming up, especially in the Supreme Court. The top court has upheld the Enforcement Directorate's power to arrest under PMLA. Now, remember, we were pointing out that 250 petitions had challenged the powers that the Enforcement Directorate has with regards to arrest, seizure, investigation. Now, the top court has ruled in favor of the Enforcement Directorate, not questioning the kind of powers it has in being able to investigate matters related to money laundering. The Supreme Court says the Enforcement Directorate is not required to share the ECIR, which is the Enforcement Case Information Report, which is the equivalent of an FIR. The Supreme Court says that ECIR cannot be equated with an FIR. Let me go across to Arvind for more details on this. Arvind, take us through some of the details that we're getting with regards to the top court's judgment today.
Maha, it means that the Supreme Court has further strengthened the Enforcement Directorate and also the Anti-Money Laundering Act. In fact, they have broadly rejected all the arguments or all the prayers that were made before the Supreme Court on this very stringent provisions of the Prevention of Money Laundering Act, right from the sharing or the sharing of ECR, that is equivalent to FIR copy, to the enforcement, to money laundering being a standalone offence. All the arguments that were put forth by the petitioner's side has been rejected by the Supreme Court. In fact, Supreme Court has gone ahead to upheld almost all the constitutional validity of the stringent provisions of the Enforcement Directorate. Let it be by initiating a money laundering probe, let it be arresting someone, let it be the Enforcement Directorate conducting searches. In fact, all the stringent provisions of the PMLA Act, the Prevention of Money Laundering Act, has been upheld by the Supreme Court. The Supreme Court has done only one thing, that is to tag this matter, because like we were reporting in the earlier bulletins, that the PMLA Act was also amended in 2019 through a money bill. In fact, the Prevention of Money Laundering Act was in fact made more stringent, because earlier only if an FIR was lodged and that particular FIR was sent to a magistrate court, and only if the magistrate take cognizance of this FIR, the Enforcement Directorate can initiate a money laundering probe based on a scheduled offence. But that was undone in 2019 amendment to the Prevention of Money Laundering Act through the finance bill, that's through the budget. That was also challenged before the Supreme Court, and Supreme Court has done only one thing. They have tagged that particular 2019 amendment with the pending matter regarding whether the PMLA can be a money bill, PMLA can be amended in money bill, etc. Something that is being heard by a different bench. They have just tagged that particular point alone to the larger bench. Rest everything, Supreme Court has outrightly, broadly rejected all the prayers, all the arguments of the petitioner's side. They have upheld all the broadly, they have upheld all the provisions of the PMLA Act. This means that the Enforcement Directorate is further strengthened by this very judgment of the Supreme Court. What is to be seen now is the detailed part of the judgment. Something that we have to see is that how the Supreme Court has interpreted Section 3 of this PMLA Act. The moment if the Supreme Court holds that Section 3 of the Prevention of Money Laundering Act is a standalone offence, that means it's like opening the gate of the Enforcement Directorate further widely. That means ED does not even need to wait for an FIR that needs to be registered by any police. ED, the moment they get to know that there is a money laundering, even without waiting for a scheduled offence or waiting for a FIR to be lodged by any of the police agencies, they can initiate a money laundering probe. So that particular point, we have to still read how the Supreme Court has interpreted Section 3 of the Money Laundering Act. Yes. But majorly, it's a major big victory for the government and also for the Enforcement Directorate.
Absolutely.